injunctions can lead to bad things. And I know an injunction for some of you isn't that big of a deal. You don't want to be around this person anyway, but sometimes later on they can lead to a lot of punishment. We're going to talk about a case where the guy was charged with aggravated stalking after an injunction, and he shouldn't have been contacting this person, and he got 10 years in prison for several phone calls within a 24-hour period. Now you may say, how do you get 10 years prison for some phone calls within a 24-hour period? And I'll tell you about those calls. The lady that had the injunction against him never picked up the phone, and no voicemail was left on any of those calls. Now, the allegation is, and the jury bought it and sent this guy to prison for 10 years. The allegation is, I don't know anybody from this prison, and yet this guy I have an injunction against for many years, he's the only guy I know at that prison, and all of a sudden I'm getting calls from that prison within a couple days of this guy getting to that prison. So supposedly the state proved aggravated stalking after an injunction. Now I ask you, when we peel the onion away on this appeal, was there actual stalking by the fact that this guy called from prison and the woman never answered the phone and no voicemails were left? Just several calls within a 24-hour period. Is that stalking? Well, stalking is defined as harassment, right? And harassment is engaging in a course of conduct directed at a specific person, which causes substantial emotional distress and serves no other purpose. So the appeal focuses on the issue of, is this really stalking? Is this causing substantial emotional distress to the person that never answered the call, never got a voicemail? Well, here's the thing. Our legislator, bless their heart, did not define substantial emotional distress. So the court has to wander around and try to define it. The court does give some examples of cases that they said, you know what? You got aggravated stalking because you have some contact that would cause some substantial emotional distress to the injunction person, right? And they cite Libersat v. State. And in that case, here's what was considered, this is substantial emotional distress to the injunction person. Here's what we got. This guy drove by her house late at night in violation of the injunction, number one. He drove by her place of employment several times in violation of the injunction. Oops. He drove by her father's house. He drove by the child's school, her child's school, not his. He repeatedly searched for her on Facebook using fake identities and sent pictures captured from her Facebook account to third parties. Third parties know that he's seeing the Facebook page, and he asked a third party to drive by her house and take pictures. And the court said, all this activity in violation of the injunction is going to cause substantial emotional distress. Go to jail, go to prison. Yes, you have stalked this person in violation of the injunction. Getting back to our guy, Ford, again, calls from prison that weren't answered, that weren't on a voicemail, nothing, and in violation of an injunction, right? And is that aggravated stalking after an injunction? That's the question to the court. And the court said, no, we don't have enough here. All the court said here is he committed a crime. Ford committed the crime of violating the injunction. We all know that. But did he commit aggravated stalking? And there must have been some evidence that Ford harassed this lady and that a reasonable person like this young lady would have had substantial emotional distress as a result of several calls from a jail over a 24-hour period. The court said, guess what? I'm throwing out your 10-year prison sentence because we don't have substantial emotional distress. We have other crimes, the violations of the injunction, those are criminal, but we don't have what you went to prison for a decade for. Now there's a prosecutor lesson built in. It would be embarrassing, like if I were prosecuting this, and I've never prosecuted a day in my life, but I would be embarrassed by this appellate decision because the appellate court says, you know what, prosecutor? You could have proved substantial emotional distress to that jury. Because you know what we did? We read the sentencing documents, and the sentencing documents revealed some interesting things about Ford and this young lady that got an injunction against him. Here's what the sentencing document said. During sentencing, they presented evidence, not to the jury, but just to the judge to be sentenced, that he has a foot fetish. Ford has a foot fetish and an extensive history of calling 911. And he has over 180 misdemeanors regarding asking the 911 ladies about their feet. The jury was not told about this. The jury was not told that back in 2012, 2013, 2016, that Ford had violated this injunction rather consistently. The jury was not told any of that. None of that's in evidence. What was also important at sentencing that was not in evidence to the jury was that in 2013, he wrote the lady a letter saying he planned to come to her house. Like, now you've got all this stuff going on. The court says this embarrassing thing. Such background state would have gone a long way towards satisfying your burden to establish that Ford's series of phone calls would have caused a reasonable person substantial emotional distress. The court says, yet none of this was presented during the state's case to the jury. And so we can't look to it to bolster your argument on appeal. There's a lesson, folks. That was a lesson. They could have upheld this as substantial emotional distress, but they never admitted any of that into evidence. The court has to follow the law. His 10-year prison sentence was thrown out of court. This is not aggravated stalking on the evidence presented to the jury. It would have been had the evidence at sentencing been presented to the jury, and there you have it.